Hi, my name is Roisin O'Dubhlaoidh. I'm an associate in the personal injury team at RWK Goodman. I specialise in personal injury claims arising from a variety of situations, as well as fatal accident claims. Today we're going to cover what you may need to know about bringing a fatal accident claim. Following a death, compensation can be claimed wherever there has been a negligent action or inaction which you believe has led to your loved one's death. Typically, when clients come to speak to me about a potential fatal accident claim, they do have an idea of what they think caused their loved one's death, such as on the road, somebody driving into the back of your loved one's vehicle, crossing the central line and striking your loved one's vehicle. In the workplace, we often pursue claims where there has been a fall from height or a crushing injury or such like involving machinery. Under the Law Reform Act, families are able to recover losses on behalf of their loved one's estate for the pain, suffering and loss of amenity they may have suffered prior to their death. They are also able to claim for any funeral expenses which have been incurred from their loved one's estate, and there may be other miscellaneous items that they wish to claim for, such as if their loved one had a particular item of jewellery that became damaged, or if they have other losses relating to their vehicle and equipment. The actual amount you might receive does vary from person to person and family to family, so this is something that we will try to advise you on in our first meeting. In terms of who heads the claim, if there was a will, then it will be the executor who heads the claim. If there was no will, then any eligible dependent can head the claim on behalf of the other dependents. It is important to note that whoever brings the claim, every eligible dependent must be included in the one claim. This is because only one claim can be brought following a fatal accident. We will work carefully with whoever heads the claim to ensure that all eligible dependents are included. In order to be eligible for a dependency claim, a person must either have been dependent upon the deceased at the point of their death or had a reasonable expectation of benefit in the future. Dependency is considered from two angles. A person may have been financially dependent upon the deceased, or they may have been dependent on their services around the home. It is quite easy to establish whether a person is financially dependent upon another. Usually this is in the form of contribution to household expenses. It may also be contributions from parents to their children or to other younger members of the family. If a person was paying for their parents' care home fees, that would be another example of financial dependency. Wherever money has moved between parties, it is usually indicative of some sort of financial dependency. When I ask my clients whether they had any services dependency upon the deceased, they typically say that they didn't. That is because it is a weird thing for people to quantify and to talk about, and people don't realise how much they depend on others in their lives for the services that they provide. For example, we often bring claims for the contributions that partners make around the home. This may include walking the dog, taking the bins out, cooking 50% of the meals, taking care of the gardening, the cars, even providing care to grandchildren. Many people do have service dependency upon their loved one, even if it is for such a small thing only occurring once or twice a year. Service dependencies can be quite a substantial part of a fatal accident claim, and we take time to try and understand the life of your loved one in order to appreciate all of the things that they provided to the people that they cared about and to try and reflect this within the claim. It really varies how long it takes to settle a fatal accident claim. One of the things that might impact this is the point at which we are instructed to assist with the claim. If we are instructed shortly following the death, then we can provide a lot of benefit to families by giving an early steer and supporting them through all the processes. However, I wouldn't ordinarily like to sit down with a family and ask them to provide me with lots and lots of evidence at this point, and I would look to them to direct me as to the timescales they are comfortable with for providing me with information. Things that will delay a fatal accident claim are ongoing investigations by the Health and Safety Executive, ongoing investigations by the police, the need to perform quite difficult and detailed analysis of financial contributions to the household. And if a person owns their own business, then it might be quite tricky to work out what their projected earnings were over the remainder of their lifetime in order to account for these. I would like to say that most fatal accident claims could be resolved within 1 to 2 years. Families may come to us with a lot of information that they have received from the police or HSC, and that might provide us with enough to be able to settle liability very quickly for the accident. We then have to think about the time that it takes to investigate the claim and ensure that it's properly quantified. If there are just a few dependents on the deceased, you can see that it would be much quicker to quantify their claims than if there was a very big family, all with a significant dependency on the deceased. We will work with you in early meetings to try and understand what the likely timescales are and to give you an idea of these. The good news is that many benefits arising from death are disregarded when considering a fatal accident claim. This means that the receipt of a death in service benefit or potentially funds from a GoFundMe will be excluded when considering a person's entitlement under the Fatal Accident Act. Unfortunately, there's no provision under the Fatal Accident Act for dependents of the deceased to claim for their own psychological trauma, unless they were sufficiently proximate to the accident so that they qualify for a secondary victim claim. Secondary victim claims are quite difficult to establish, and I think that is purposefully so under the legislation. You are most likely to qualify for a secondary victim claim if you're present at the accident when it happened. I'm often asked this question by families. Something really useful to realise from the outset is that the burden of proof in a criminal investigation is much higher than the burden of proof in a personal injury claim or a fatal accident claim. The burden of proof in a criminal case is beyond reasonable doubt. The civil burden of proof is much easier to meet, being on the balance of probabilities. This means that we can quite often persuade an insurer to admit liability for the civil claim before the resolution of the criminal case. For example, if somebody drove onto the wrong side of the road causing an accident, it is quite clear that they have engaged in a dangerous standard of driving that has caused an accident and resulted in a death. This means that whilst the police may still be gathering evidence for the criminal case, we may be able to conclude your case long before this. If you think that you have a fatal accident claim, RWK Goodman are on your side. We offer friendly, no obligation advice, and we're really happy to take you through some of these questions as they are specific to your case. If you'd like to find out more about how we can help, have a look at the links below. Thanks for watching.